Greetings, everyone. Welcome to another podcast of The Essential Talk. So, what's essential to talk about today is corporate law, for which we have Mr. Vinod Dixit. Mr. Vinod Dixit is an active director of four private and public limited companies. At the moment, he's working with Escorts Finance Limited, and we're really glad to have you on board with us, sir. So, without further delay, let's begin. So, sir, commercial and corporate law has been an emerging trend lately. We've seen, but lately a lot of people do not know exactly what it is. So, can you tell us the difference between the two?
Yeah, actually, firstly, I would like to speak on the corporate law.
Yes,
Is
sir.
basically a field.
Okay.
It is not a law.
Acha.
It is a field. Basically, you have to select the field first.
Mm-hmm.
Corporate law is a field where the number of laws are coming. Company law, labor law, security law, banking law, every law are coming under the corporate law. Firstly, this is the field which you are going to, as a BBA or a law student, you will have to select the field. This is the corporate law field.
Very
And
well, sir.
in the corporate law, most of the company formation, how the company is being formed, what will be the equity of the company, what is the how much shareholders will be there, when there will be public issue, what are the other things related to particularly Company Act and other related law where the formations are coming. In case of the commercial law, it is just like saying somebody is saying a business law.
Okay.
Commercial law is business law where the number of laws are coming, where the sales of goods act, sale and purchase,
Right.
where the services are being taken by the company, where these law are being applicable, like GST law, it is service law, and other law, labor laws, where all the laws are coming, where most of the battles or most of the cases are coming from the commercial laws.
Oh, okay.
In the court, if you are going to just do the practice, most of the where we are deviating, any organization is deviating any law, commercial law, then it will be a legal matter.
Ah.
So this is the some sort of commercial law which are basically involved in the day-to-day operations of the company. Everywhere, like in labor law, it is administered by the labor law, and in case of sale purchase, it is a contract, it is agreement, vendors development, all these law are affected. These are the commercial which are coming into the foray for the operation of. You will have to understand between the corporate law is a basically field which covers the commercial law.
Right.
But mainly it is going to corporate law. In the formation of the company, shareholders, acquisition and mergers are in the corporate law field.
Oh, interesting.
So, sir, you very well explained the difference between the corporate and the commercial law. So, as a student and our viewers who have just joined the law school, so like what field, under what field the law field, sector they should enter, for basically between the corporate and the commercial. So, what should they opt?
Basically, corporate law field is very vast field, and very important as on the current business scenario. And in this, we are covering number of law. Business law we are covering, and we are covering the company law. We are covering the security law. We are covering the contract law, and we are covering the banking, insurance, pension. Every law is being covered under the corporate law. And if you coming to the international law, these are also being covered under this corporate law. The number of things which is covered under corporate law and very good opportunity. In the commercial law, basically it is civil matters. All the civil matters go into the commercial. And they are arising from the commercial law. Like any contract you have done, any vendor, and you have deviated, vendor has a right to file a case against you. You will have to file. In case there is a default in the payment, there is a defective material supply, there is a agreement that you and to supply number of deficiency in the services. All these comes in the commercial law, where the cases are being arrived and you will have to just face the litigation. But so basically,
Right.
as a corporate lawyer, you will have to knowledge both of the law. Otherwise, you cannot succeed. In the once you are doing the corporate law, basically you have to just see the secretarial aspects of company like very important role where the company is being formed, what is the memorandum articles of the company, how what are the powers are given, how the company framework has been defined, what is the authorized capital of the company. All these come in the memorandum articles of the company. That is very important document under the corporate law. You will see then thereafter issuance, public IPO are coming, FPO are coming in the market. Then people are investing, shareholders meeting up, all are coming in the corporate now.
So this means the students and the viewers will have a great opportunity in the future.
Yes, 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 definitely there is a greater opportunity in the corporate law, and there are very less number of persons who are aware about the importance of the corporate.
So moving ahead, what made you choose corporate law as a field of practice? Was it the numbers or the or the combination of law and numbers?
Basically, it is always any field is being chosen as per the interest of the person. If I am doing there, I am doing some ethical field.
Right.
If you ask me why you have selected the pathway, my interest was to go into the secretarial aspects. As a company secretary, as a CA, or these things, financial matters. I was in how to do the investments, how will be the how to rate the company, how to read the balance sheet of the company, annual report, how what are these contents are there. Every things I was to use to do that. Then I have selected that. Apart from the secretarial aspect, I will have also to do that. Yes, particularly corporate and where the merger and acquisition, number of IPO, right issue, bonus issue, public issue, all are I have done it. So I have very good interest on this corporate stuff.
Wow, that's very interesting, sir. Because secretarial stuff looks very fascinating, but it's actually a lot of hard work that goes into it. Be it the numbers, be it the information, it's pretty much of a big task, actually. And it's more like people this time do not know what exactly mergers are, right? So like maybe they just know a vague definition, or they don't even know that in today's time. It's just the fancy words that we're using in today's time, which is creating a hype. Right. So can you tell us what exactly are mergers and like what kinds of mergers do we have in today's time?
Actually, the merger and acquisition is a very important role to grow in this particular
Right.
business books.
Definitely.
And while doing the mergers and acquisitions, there is one more word is amalgamation.
Yes, sir.
Amalgamation is also part of merger. But there is a little bit difference between the mergers and amalgamation.
Oh.
In case of the mergers we are doing, we are just consenting two companies and may create a new company or may not create a new company. Like Maruti Suzuki and Suzuki of Japan has done the merger.
Oh.
And they have formed a new company,
Okay.
Maruti Suzuki India Limited.
Oh, wow.
So this is the merger.
Merger.
In case of amalgamation, where the business line is the same,
Right.
but somewhere we have consented each other, but major company, big company merge the company, amalgamate the company a small company to get close the competition, to get the better synergy of the product, to get the better market of the product. So that is the amalgamation. It is one bigger company acquires the small company. It is amalgamation. There is a difference.
Right, sir.
You have understood there is a difference. One set of business, two line of business, it is going to the mergers, and a new entity can be created.
Definitely.
In case of amalgamation, the small entity goes away, and big company may arrive. And secondly, in the case of merger, all the assets of the companies when it is merged, the new entity are being rebooked in the balance sheet of the company. Wherein the amalgamation, only the new assets which are amalgamating that are being recasted in the balance sheet of the. So these are the financial difference. I said similarly there are creditors also. In case of mergers, the creditors are being looked into, and that creditors meeting is being done. Shareholders meeting are being done. That meeting are being conducted under the direction of the NCLT. If you see, in 2016, government has decided to create a new entity, National Company Law Tribunal. Earlier,
NCLT,
all the
yeah.
mergers and acquisitions were handled by the High Court. But what happened in 2016 when the merger cases were coming very frequently, then government has decided and created a new body, NCLT.
Right. Hmm. Right.
This is very popular, and in case you are going into this field, then you will have to definitely visit the NCLT. In Delhi, there is a office in Lodi complex, and
Yeah.
there is a NCLT. 3 branches are there because of the number of cases are going there.
Uh-huh.
And as per Companies Act 2013, number of items have been given. It will be approved by the NCLT.
NCLT, right.
And while doing this merger and acquisitions, in the merger, if you see, there is a new entity and there is a new sort of entity being created. Like there were A and B company, XYZ company, and then they have created P and S company.
Okay.
In case of amalgamation, that is not there. In case A company amalgamate B company, a small company, A company will be exist and B company will go away.
So it's more like a takeover that happens, right?
Yeah, it is a takeover, but it is a consented takeover. In case of mergers, and that mergers may give you some sort of share swap ratio.
Right.
Shareholders get the shares of the company. Both the shareholders company, in case new company is being created, both the company shareholders are getting the new shares of the new entity in the assets wise.
Right.
Like my book value of the company is 100 rupees, and the another company which is going to be merged in this entity, and 60 rupees. Those assets and liabilities will be reconciled.
Joined.
And before merger, there is a process of due diligence.
Okay.
Due diligence is very important. Where the CA role is coming, chartered accountant role is coming, where the advocate role is coming, the PwC, Deloitte, KPMG are coming in. They are very active in this. They are just coming and just doing the due diligence on behalf of their team. In case of mergers, so I just describing in case of the mergers, the new entity being in case of the amalgamation. And third, you have asked like acquisition. Acquisition is also basically just like I am very quick company. I am just decided buy this company, and there is a without consent. With consent, both the things are achieved. Like we have purchased the shares of any company, controlling stake we have taken, and thereafter we have given out. That's that is also like I have interest in some other company, whether it is with in line of the business or it is not in line. They are the different interest, but we have interest in that. We have think of we have the bought of the shares, controlling stakes, 15%, and then thereafter we can give an offer as well as SEBI. This is the takeover. What is there? SEBI has regulating in this market, where the takeover is done. Like recently, if you have seen about 2 weeks back, Adani has bought the yes, yes. If anybody has gone through the whole scenario.
So I didn't know what to the whole scenario, but I said with this COVID and the views of the people for that, they are think Rani has been sort of outside takeover over the entity.
So,
It is very controversial.
Yeah.
Because of the editorial and the.
Yeah. And I am telling you what happened is in case of the Adani, they have some company, media company in their Mexican company. And earlier only in case of money, Reliance Industry had some sort of influence in the media. They have taken it for everything. In case of money, the media. In case of Adani, they had also formed a new company. And they have taken one company, Superman, PCPL, if Superman, commercial private limited. A company is a holding company of entity, where the PCPL company was holding 29% share capital of this entity, and 32% was holding by the promoters, Pranora and Radhika. And this company has taken DCPL has taken a loan of around 400 crore from one of the companies, Senano Retail Limited, that is from Reliance Industry. It is a Reliance Industry has given loan to this company and they have taken this loan. DCPL connected to this company and they have taken that loan. While taking the loan, giving the loan to the DCPL, is they have taken 29% stake of the entity at that point of time. As well as they have taken also some convertible warrants. There is warrants. Are you aware about the warrants? They are basically like equity debentures. There is a warrant of that. They have issued some warrants in 2010 and 11 that while giving the loan. And the warrants were convertible into one equity shares, and whatever the loan has been taken by this promoters of the entity, that was the interest period. But they have given option against the loan, they can convert the this loan into equity shares. While conversion period was not defined. Earlier, nowadays, what happens when maybe warrants are being issued, 5% loan, 25% upfront amount you have. Otherwise, it will not available for issuing from law. Minimum 25% you will have to pay, and another 75%. Over 36 months, 18 months, or 60 months, whatever the period you decide. Then thereafter you can convert. But the price can be determined at the, in this case, they have not decided the thing. They have not taken because as per the company act 1956, there was no requirement of taking the particular 25 years. In 2013, there is a restriction that there is a mandate that free warrant is at 45%. Otherwise, what happened earlier, promoters will be seeing.
This was like basically a benefit to the promoters.
Yes, promoters. Basically, promoters were issuing a warrant to their side at the rate of 10 rupees. And they want, they can convert the longer periods into equity share when the share price is 100 rupees, they are converting into. And by way of that, converting their shareholding goes up and they are investing. That was done in this case. And the Mukesh Ambani subsidiary was there, and that company was given an insurance company. And presently on this August month, that conversion of province were purchased by this Adani Group. Basically, they have given against 430 crore loan, 434 crore of loan in 2019. They have purchased it around 113. And again, this but this was the owner was this particularly Victor Nahata, who is very close to the company and is the director of the who has sold the particular warrants and also the sold the entire building of NDTV to the this company. Once they have taken over, within 2 days, they have given a notice to the company that we want to get it converted into warrants. shares. Once all the loan has been converted, then they are the full source owner of the particular UCPL, which one commercial private limited. By virtue of the holding company, now they have got the 29% of NDCP. They have a right to build the open offer. And they have appointed PM Financial, PM Financial Merchant People, and they have decided they will buy the NDTV shares 294. At least, they want to buy at least 51% equity share only. And I think the offer will come in the month of next month. And presently, the share price of NDTV is going around 360. Offer is in the discount price. That is 94%. In this case, they have taken over all the parent side or two of direct in the hospitality without taking any community, without taking any knowledge, and they have between the 2% charity and take on over.
So, just so that issue, the share price of the is around 390 crores. So, and we also heard about that the next month there will be an offer for this open offer. So, as a shareholder, would it benefit to me or not? Should I invest in it?
You have no option for you. Basically, while company will give this offer in the public, because you are holding 100 shares, you will get an offer from Adani company that this you would like to give a share at the rate of 92 or not. You have an offer. Whether you accept it or not. Being a listed entity, you will get an offer to Silka, stock exchange Silka, and it will be you will have to click on the like you are applying the similar way you will have to click on the Silka. Your offer will be booked. Once the company will decide, then you will get the notification after the approval. But being it is in discount, it is not beneficial in the instant of the same. But if you see the earlier price, before offer, about a year back, the share price was only less than this. Now it is able to take over in column to this PMS. In case the Adani didn't get the 51%, then they can all come with the next offer also. They can revise it also. 294 can be revised 390. There is no limitation. This is the buyer willingness that they will buy it. Only they will have intimate facility. That this is the offer we have taken at the client and we are not giving what to this. We are revising other people. So in that case, in case it is being revised, definitely there will be. Otherwise, this is a very big company and anybody hold the shares on set will be.
You explain this topic very well. So, if you also explain the kind of even you were telling about the merger and the acquisition. So, should it be possible to explain the kind of merger?
Basically, if you see the merger, there is some four types of merger are very common nowadays. Horizontal merger and conglomerate mergers. Then generic merger and then vertical. These are the few actually, otherwise there is forward mergers, reverse merger, and cash mergers where sellers are not getting any profit, but they are very not frequently happening. In case of the horizontal merger, there is same kind of business company are doing, and they are come together, making it that we have some merger, and they anticipate that they decide this in the ratio also they will get the same. So there's some sort of the horizontal merger where there is nothing. And in case of non-local merger, there is a very totally different. I am manufacturing X items, like we are manufacturing this, and we are going to purchase a television cost, take some technology. That will be a very conglomerate. Well, there is no relation between the product and what you are doing. And in case of the vertical mergers, in case of the vertical mergers, you see there in the mergers where the product line is the same, but the companies are in different stages. One is a very big company and that is established company, and you are a very recent startup or someone have a very less position in the market, but you are building as a competitor. In that case, we are deciding that in case we merge it, then it will be basically very powerful. In fact, all the mergers and acquisitions are being done for the inorganic growth. In case we build a new company, then there will be a lot of time it will take, money will be paid, you will have to create a team, you will have to establish a own the permissions, you will have to establish a plant. Everything has to do and it will take a time. To avoid this period of the growth, we are complete our thinking that we just take 10 months or something so that our growth will be on higher side and we can take the benefit of everything. This is the basically why this merger and they are taking everybody wants to get the quick money. Similar way they want the growth very quickly in their future. The competitions definitely the competitions also get while merging with another company. Then the competitors are we can take the rates very well. We can take the prices. We can basically we can get the team also. In case we have a team, number of in the team will be also important. Synergy also important. That's why the merger is very important. And in organic growth, taking every company, it has a many asset company. They are
I think have like a lot of time. Why can't there be just like one merger which will be easy to do and stuff? Why do we have different aspects of it? Why can't we form a platform for all mergers one?
in case of this with particular mergers, mainly mergers which you have seen in the same line.
Like,
Same line of different horizontally mergers have been very long. Because in this case of we are aware this is my product and this is your product. And in case we merge together, and then our company will be bigger size, and we can command a very good value. We can decide our price as per what we. So this is the function, and in this case of function, this is a very powerful and hostile takeover and it's not very enormously. Like you have mentioned that earlier, this Reliance.
yeah, it's really fast about that. Like we heard about the land. There was this acquisition that took place, which was between Big Bazaar and Reliance Legal, right? So in that there was a lot of controversies which also were going on because of the Amazon, which claimed that they would be taking up future stocks and everything, right? So in that, what would you suggest? Like, what actually is your viewpoint of that?
Reliance and future retail investors. Basically, it is just like a concentrated and they have not disclosed the future retail has not disclosed the correct picture to the investors. And they have not disclosed that this is the binding estimate which they have done with the American. Basically, whatever the product and other thing they are selling, they will have done that they will sell to the particular Amazon platform. So that they have not disclosed. So I the Competition Commission of India and rejected the application of government. And presently, this Reliance and Big Bazaar deal is also off because the traders are not consented and the deal is not consented.
Well, not available.
This is not going to happen. And they are Big Bazaar is now in default. They are not paying the vendors and the creditors are filing banks.
So that what that the papers are filing for the subscription or the other song. People.
Because Reliance has data because the creditors have not approved that deal.
They will get back.
Yeah. Now the big majority don't have to pay them. They will have to see the insolvency process. Like creditors has already they not get the money, just principal and they are ready.
You also know about the due diligence process earlier. So, merger, the department of which they got the merger and acquisition. It's requires a lot of skill set. So, what should one? So, what skill set what should possess while
Basically, there is a process. While doing the merger or something, due diligence is very key role in the without key role, firstly, both the parties are consented. But how much what they will get? What will the beneficial? Who will be the beneficial more? It comes only after the evaluating the assets and liabilities. What are the assets and liabilities are there in the books? Whether the assets are in good condition or it is in bad condition. Now the role of the due diligence detective, to advocate or some others, they are just evaluating the event. And in due diligence, they are doing on the whether the title of the land is good, they are how many cases litigations are going, what are the consequences in the books, what are the employees provisions have been done with and not properly, they have complied all the rules and regulations. Because once they find that all the regulations have been followed, then they come out with some sort of valuation part. In the valuation part, the negotiation is proceeded. Negotiation is still one of the important things where everybody wants to get and that is we can say that this is the position of your assets, which is not good as per the law. However, it is booked in the overvalued in the books. So this needs to be correct. Title is not good, plant is very old, and the manpower which you have to get the money is good. So number of things are coming. This is the negotiation part where we can just say, okay, I think this is the real value. And this is the real value. Like only the two things cannot be clubbed. Like my revenue, my sales is 100 crores and your sales is 50 crores. Then you can decide that my value is 100 rupees, your sales. That cannot be put in a deal. And in case of the due diligence, number of things, whatever the balance sheet of the company is, that need to be evaluated, how the title is, all the cases which are going on, which need to be evaluated. And future prospect for the vision of the company is also important. What is your plan? How much you have invested in the assets, capital expenditure, capital, after technology, all these things comes together to evaluate.
So, like, all these mergers and acquisitions seems a lot of fancy, very fascinating, like when we're learning about it and everything. Because we see like a lot of big companies who are present in this field, who are into all this business. And it's like the grass always green on the other side, right? So I guess must be some actual reality checks which would actually be there, and it's not like on fancy. So what's the reality check? Like what's the actual process of a merger and or a negotiation, anything?
While the due diligence and the negotiations are completed, then the process will then you have some agreement in these and between the party that is just binding agreement. Before due diligence, there is a non-binding agreement and there is a time frame and free time here. In this period, you will have you will have to see all the assets, you have to all the liability, see all the things, whatever you would like to see. This is the they are providing the documents. Once it is finalized, then valuation card and it will be then there is a finally agreement. Then the process is started. Then matter goes into the board of directors. Board of directors are both of the team passing a resolution of them. And in the new company that section 34 are there under which we will have to pass a resolution. Then in the resolution we will have to just give authority to file various applications. Like in the stock exchange, we will have to file the application. Take their you will have to file the application CPE. Then, after taking the approval, you will have to file the fixed interest. Fixed rate was the matter goes. They are giving a notice to the each concerned party. Each concerned party means they are ROC, the nature are complete by missing party. Partner. Then they are giving to the notice to the traders, shareholders, and then they are also all these things asking for this in the report. They come out. Subsequently, does all the meetings, shareholders meeting, NCLT calling the meeting, and they are appointing the chairman of the meeting, then co-chairman of the meeting, then scrutinizers. These four persons are being nominated by the for conducting the meeting fair conducting where the company is conducting and all the figures are coming. In case the resolution will be approved by the member, it is approved by the shareholders. And then only the report will be filed in the newspaper. Secondly, in case of operators, there are secured creditors like banks and other things. There is unsecured creditors like fixed deposit holders. There are normal vendors, others. They have objection. They can also file it. Objection, one number. Then company has settled. They can raise the objection. They can vote against them. In case of the both the resolutions are passed in the meetings, then the report is scrutinizers are filed in the NCLT. NCLT will review those particular scrutinizers. In case it has been approved, then only they will carry environmental issues. They will listen and they will also see whether the ROC has given consent. Income tax department has given consent. All the consents are in all the regulatory body, the consent are in place. NCLT has to verify. Earlier in the old company, yet, and the particular OL was to see the all the things. One chartered accountant was also appointed to the other things they are giving the reports. Now this case the auditors of the company they are giving.
I think the SBI is like playing a very major role in this.
Because they are
Very crucial.
very crucial without them, no scheme can be approved.
So when the process of the copiers of the application indicated, and one of the department, let's say, disagrees with the proposal to suspend the liability. So would the whole process start again, or they can continue from wherever they yeah, that's very important.
Because once we are developing a scheme of arrangement of all the things are there. These are the creditors and these are the creditors and this is the shareholding, this is the pre-shareholding, this is the post-shareholding. That is what document is being circulated to all the creditors and shareholders. If they are not approved, so then the merger can happen. NCLT will not approve and merger will go off.
This very well, and I hope
Because the scheme of arrangement is basically document where both the parties has signed, both the board of directors and signed and proposed it, approved it. And once the shareholders agree, they are agreed. Like institutions board, financial institutions, sometimes they are not approved. Sometimes banks are not approving it. They are voting against the scheme because they are also pushing their income. So what will happen to my saving? Like we have invested 500 crores of this company, and in the new entity or in the old entity, our share price will go down. They are not approving it. So once they are not approving it, it means that the merger cannot take place. Both the company will be an ideal.
You're like too much of experience that I can see from the talks that I've had with you in this very short span of time. What are some, some advice or some tips or tricks which you would like to give our students or us budding lawyers in general to, learn from this?
Like sincere advice, firstly concentrate on the subject matters because once you are concentrated, you are just reading the books. Theoretical parts is strong. Then only you can see the legality of the documents, like scheme of arrangement, merger, being what contents are required. It is available in the books. So any students or any who is doing this academically, they should concentrate on theoretical part because the practical parts can be seen in the other normal practices. You can see the scheme of arrangement, you can see in on that basis you can walk it out. But where it is wrong, you can find out only once you have a knowledge. Otherwise,
It's more is the thing of more important.
yes.
Knowledge as well as many experience which
Yes.
you fail to.
Like once you have a knowledge, each are the particular provisions are applicable to this and particular section apply to this and this falls into the amalgamation, this falls into the merger and this falls into scheme of application. So if you understand both the three, then you can create it. You can file you can do the agreement, you can create a document, binding document between the parties. So that is the more important. And once you have created, and basically, when you said that as a lawyer, firstly, you have to see where is the real is. Like somebody, I have an investment at criminal law. I litigate, I mean, both of them, and litigate. गए अपना कोर्ट में नहीं साहब इनको तो जमानत मिली थी because he has not done anything. Now FIR has only been filed and everything and so how you are proving, how you are evidencing the situation, that is important. Anybody can say he is innocent and he has not done anything, but he has done. So litigation is basically the criminal part where you have to understand the rule, the act as well as the law. Similarly, corporate law, you will have to understand the law first because you don't have to litigate. You will have to convince that we have taken the approval, we have taken the compliance of all the regulatory authority, whether is required in the system. And this is the position where I am coming, and this is the section permitting us to give the present approach. So
The negotiation.
one of the knowledge and the negotiation, particularly convincing power.
The basic power plays a major role.
Yes. And convincing comes once you are fully have a full knowledge of the subject. Otherwise, you cannot convince anybody can do why this section has been missed. Why you have not put the application in this. To have a base on.
So with that being said, we would end our today's podcast on a very good note, and we would also thank you for the
So glad it came.
So, it's a
Yeah, so
pleasure to me and in
it
case
spared so much time for us and you inspired so much. Thanks to you, sir.
not a due to time limit, I have not taken it to small process. But this is very vast subject matter. In case you are drafting any agreement or you are drafting a scheme of arrangement and it takes too many And you will have to gather the information from all the companies and just put it in the same kit of the scheme. That is all scheme of is there anything.
And I also hope that the today's podcast would also help our viewers to understand the basics of the mergers and acquisition, and they would use this in their practical life very well. Okay, thank you so much.
We're glad to have him.